Ready, start. A purely academic question covered by a binding precedent of this court is agitated unnecessarily by the respondent herein and entertained egregiously by the High Court. The High Court has also refused to follow the binding precedent of this court on the ground that there is a reference made to a larger bench. The reference, as pointed out by the appellant, has been closed unceremoniously on default. The records of the appeal reveal that a young married woman of 25 years of age died on 16/2/2021, which led to an allegation of harassment and torture at the matrimonial home and counter allegation that the deceased, together with her parents, misappropriated cash and jewelry belonging to the family of the husband. A cousin of the husband of the deceased filed a complaint before the police in which the deceased's father and mother were arraigned as accused. Upon investigation, the investigating officer was informed that the second respondent acted as the agent of the father of the deceased and threatened a witness who alleged that he was privy to the extortion demand made by the father through the second respondent. The IO hence required the second respondent to be subjected to a voice sample test for which collection of the voice sample was sought before the jurisdictional magistrate's court. To this end, a petition was filed before the jurisdictional magistrate, which was allowed by Annexure P13 order. The second respondent challenged the same before the High Court, and the High Court, by the impugned order, set aside the order of the magistrate, finding that a similar question was referred to a larger bench. As has been rightly pointed out by the learned senior counsel for the appellant, that the said reference has been closed as per Appendix B. The reference, as we see from the questions extracted in the impugned order, was whether the direction of this court enabling the magistrate to pass an order directing the accused to provide a voice sample would apply in the case of a witness. In the present case, the question is raised especially on the ground that it would lead to infringement of the right of the witness under Article 20 within bracket 3, which on comparison of the voice sample could result in arraigning the witness as an accused. This court was concerned with a conversation between two accused who were alleged to have collected money from different people on the promise of jobs which did not materialize. The specific question raised was with respect to the magistrate not being empowered to pass an order directing furnishing of a voice sample. We specifically note that this court had not spoken only of the accused and specifically employed the words single inverted comma, a person single inverted comma close consciously because the rule against self incrimination applies equally to any person whether he be an accused or a witness. It was also directed that till explicit provisions are incorporated in the CRPC, the judicial magistrate will be so empowered by virtue of the said judgment.